Benjamin Wittes, and this is the Lawfare podcast shorts, an update on the Oath Keepers trial with Roger Parloff, who has been covering it for Lawfare. Roger, it's been a week since we did our last Oath Keepers trial update. What's been happening in the courtroom?
Yes, I think we might be halfway through the prosecution's case at this point. They predicted about 3 weeks. We've been through 2 weeks, although with 2 vacation days. And we've seen 9 more witnesses since we last talked, 8 of them FBI agents, or in one case, an FBI liaison. He works for Capitol Police. And I think that sort of says it all. It's been mainly documentary evidence, signal chat, some letters, some previously recorded videos by Rhodes, a lot of documents so far. We had one new, the 4 sort of non-FBI fact witnesses have all been associated with Oath Keepers, and we heard from one of those since we last talked.
And have there been any surprises in the prosecution's case, or is it much what you would expect given the text of the indictment?
I think it's pretty much what was foreshadowed by all of the indictments and the filings so far. These Oath Keeper witnesses so far are not the marquee ones. They're not the people that pled guilty that we're expecting to have a lot of vivid and interesting and hopefully new information. The latest one was sort of interesting. He was really walking a line. You almost wondered why he hadn't taken the fifth. He hasn't been charged, but he's walking a line. His name is Cummings, and Terry Cummings, and he did come to January 6th. He's a low-level guy. He came with one of the defendants, Ken Harrelson, and with a guy named Jason Dolan, who pled guilty. And he brought a firearm. He checked the firearm with the Comfort Inn Hotel in Virginia, the QRF, the Quick Reactionary Force. And then he came in on January 6th. And he says, they were supposed to be on a security detail for a Latina woman, and he doesn't know her name. And then when they saw the rioting, they left her with one Oath Keeper and continued toward the Capitol. And then he heard Kelly Meggs, one of the defendants, say that the Capitol had been breached. And then Meggs brought up whether they should go inside the Capitol. And at that point, and Meggs was going to speak to somebody else, and Cummings said he didn't know who, but obviously it would have to be Rhodes to see whether he should go in the Capitol. And at that point, Cummings decided to go to a porta potty. He needed to go to the bathroom, and when he got out, the others were gone. And then later he rejoined them, and sure enough, they had gone into the Capitol in the meantime. So he was obviously he said some things that were helpful to the government, but he was obviously not their enthusiastic witness. And in fact, he's contributed to the defense funds of Harrelson and Meggs, 2 of the defendants. So he also provided helpful testimony to the defendants in terms of talking about how the Oath Keepers, he joined them in order to fight Antifa and what a menace Antifa and BLM were during that period. And he does believe the election was stolen.
So what have we learned so far about the defense? The defense hasn't presented any of its case yet, but it has had the opportunity to cross examine these various witnesses as they've come forward. Can we get a sense of what the defense of these various defendants, particularly Elmer Stewart Rhodes, is going to look like?
Yeah, we are beginning to get glimpses, um, and um, it's easier to tell what the defenses of the non-Elmer Stewart Rhodes defendants are. Um, I guess with all of them, a defense is going to be that, we've looked at, obviously, the FBI has looked at tens of thousands of signal messages, and they have not found a sort of a smoking gun that says, here's the plan to breach the Capitol on January 6th. So there's nothing like that. And so that's a hurdle.
And just when you say it's a hurdle, you mean in the sense that if a seditious conspiracy is supposed to be a conspiracy to defy the lawful authority of the United States and obstruct its proceedings, presumably the absence of a grand master plan to enter the Capitol and obstruct the proceedings is something that the prosecution has to establish a conspiracy in light of that, despite that absence. Is that what you
Yeah.
mean?
Yeah, you want to go beyond revolutionary bluster, I think. Um, because there's almost a sense here. I mean, I could see somebody, a juror like me, for instance, thinking, these are sort of deranged big talkers, but were they really going to do something? And without that specific plan, you sort of wonder about it. It's almost like a dog that chases a car and then catches it and doesn't know what to do. There they were, they'd been talking big for 3 months, and somebody has breached the Capitol. You sort of have to go in. And that's, I don't know if that's seditious conspiracy.
So you mean they could be, just to nail it down, they could have talked like there was a plan, and actually breached the Capitol like there was a plan, all without a plan.
Yeah, I mean, at some point, obviously, I think there is an agreement to go in the Capitol, and I think that gets you uh, a corrupt obstruction of an official proceeding. But I it's I don't know if it's one and the same as all of this revolutionary bluster we're seeing beforehand.
Now, are there lesser included charges? I mean, if a juror comes away, or the jury comes away saying, "All right, look, they clearly went in, they clearly agreed to go in. That's some kind of conspiracy," but I don't connect it necessarily to the revolutionary bluster from before, or as the government is presumably going to show, from after. Is there some kind of lesser included conspiracy that they could find?
Yes, they're charged with three different conspiracies. And the second, besides seditious conspiracy, is conspiring to obstruct an official proceeding. And that's a 15-year felony. That's the main felony that's being used against, you know, I think close to 300 other January 6th defendants. They've also charged 18 USC Section 372, which is the criminal Ku Klux Klan Act conspiracy, which is a conspiracy to disrupt or prevent federal officers from doing their jobs, and in this case, the congressman. So there's also sort of conventional obstruction of justice charges for destroying evidence. So yeah, there are other charges. They didn't charge them with misdemeanors, the usual underlying misdemeanors entering and remaining in a restricted zone, because I think, they really don't want to come away with a misdemeanor in this case.
We are going to leave it there. Roger, we will catch up with you again next week.
Great, thanks.